Greetings. Today I will be discussing the case Jurin vs. Google. Here's some background on the case. The case Jurin vs. Google was opened when Daniel Jurin sued Google for using his trademarked word of styrotrim as an ad word. An ad word is an ad service that Google offers that allows a company to have a higher placement than other natural and organic search results. Daniel Jurin sued Google because companies were able to buy the ad spots above his company when someone searched styrotrim. An additional argument brought forth by Jurin is that Google made money off of Jurin's trademarked product through ad money, just by using the trademark name. Here's an example I've chosen. I searched the term "buy hazelnuts." Now, everything in this list is hazelnuts, but everything here, if you look in the top left corner, is the word ad. All of these items here have been paid by these companies to show up above all the other natural search results when someone searches by hazelnuts. So, nuts.com, as the first website that you see here, paid the most money out of these three, but in ranking order, Nuts Stop paid second, while Sun Organic Farm paid the third amount of money, but which listed them all above the natural search result that came next, which was an Amazon link to buy bulk hazelnuts. The biggest concern over the case was whether it violated the Communication Decency Act Section 230. Google suggested styrotrim as a keyword to companies bidding in AdWords. This allowed competitors of the plaintiff to appear above the plaintiff's business in Google search result for styrotrim. The court stated Section 230 applied because suggesting a term gave the choice completely up to the bidders and did not mean Google was making any infringing content. This is a quote from the case. By suggesting keywords to competing advertisers, the defendant merely helped third parties to refine their content. This is tantamount to the editorial process protected by the Communications Decency Act. The defendant's keyword suggestion tool hardly amounts to the participation necessary to disqualify of Communication Decency Act Section 230 immunity. Rather, it is a neutral tool that does nothing more than provide options that advertisers could adopt or reject at their discretion, thus entitling the operator to immunity. In this case, the biggest issue was other companies chose to bid on the word styrotrim, and Google was not at fault for even suggesting that it was a word that they could bid on. Progression of the case. The first time Jurin sued Google, his lawyer left the case, and he voluntarily dismissed the case and was given a $6,000 sanction against him for it. The second case, with a new attorney, argued a false association claim and won an intermediate case before the new attorney left Jurin, and the court decided a ruling favoring Google. And this is a quote from a Forbes article, "Google Defeats Trademark Challenge to its AdWords Service," written by Eric Goldman. As a result, Jurin didn't contest Google's summary judgment motion, giving Google an easy courtroom win. With minimal analysis, the court said that Jurin didn't provide any evidence of actionable consumer confusion, false advertising, or sufficient fame to support a trademark dilution claim. That means that when Google had these advertisements above that did not cause consumer confusion, whether what was the true styrotrim and what wasn't, it wasn't false advertising, meaning it didn't direct people to something that they didn't want, or it didn't cause enough damage to Jurin and styrotrim's fame, causing a trademark dilution, meaning that the company word of styrotrim was worth less money. It did not cause any of that, is what the court argued. The result of the ruling was that Jurin vs. Google was the first time that Google won a full final judicial decision concerning the legitimacy of the AdWords service, and also allowed concrete proof that they could sell trademarked keyword ads. The case also further discouraged companies from suing Google. The AdWords service is nearly their most profitable service and was strongly and still is strongly protected by Google. And then shortly after this case, Google won a following case against Rosetta Stone, a company with more money, arguing the same position because they had people bidding on their word Rosetta Stone to end up as a new learning service for learning a new language. References that I used was a Forbes article, Google defeats trademark challenge to its ad service, and then a Electronic Frontier Foundation, Jurin vs. Google Incorporated, and then a Harvard Journal of Law and Technology article titled Jurin vs. Google, Plaintiffs' Lanhams Act False Association Claims Against Google AdWords Program Survives Motion to Dismiss. Thank you.